We are starting panel number 3, Landscape in India for Foreign Portfolio Investors. So this is going to deal with the framework of the FPI regulations, Foreign Portfolio Investment Regulations, some tax issues, and participation of non-resident Indians, eligibility to deal in offshore derivative instruments, aggregating investment limits for FPIs and swaps, P-notes, and implications of FPI regulations in the India-focused hedge funds question answers. So we have Kishore Joshi, Rajesh Seman, and Rishi Sancheti. My first question to you all, how many of you have made portfolio investment in India? Oh, quite a few. Okay, great.
Or help clients.
Huh? Or help some clients invest. I think the same thing. Yeah, good. So, Kishore, would you just like to talk a little bit about how is the regime shaping up for, direct participants, and are there any issues in that?
Sure. Thank you, Nishit Bhai. So as we all know, the FPI regulations replaced the earlier FII regulations by SEBI. It was last year in Jan 7, 2014 that SEBI introduced these regulations. Of course, they came into effect in June. So it's about 10 months that these FPI regulations are in place. The important thing, of course, that had happened pursuant to the FPI regulations came in place is that SEBI has delegated the authority to the domestic depository participants. So it is now not the SEBI, but the DDPs to whom the applications have to be made, who will process the applications, and in fact give the approvals on behalf of SEBI. So that's first major change that has happened as far as the FPI regulations are concerned. To help, of course, the DDPs to process these applications and this whole process, SEBI came out with the guidelines, operational guidelines for these DDPs, listing down some of the terms and conditions as to how the DDPs should be dealing with the issues of the applications to be made. When the regulations were introduced, of course, there were a lot of questions in the minds of the existing FIIs and sub-accounts, and so also in the minds of the DDPs. And that's where a lot of meetings used to take place with the regulator, that's SEBI. And that's where SEBI came out with FAQs, what is called frequently asked questions, to clarify a lot of queries that were raised by the different participants as also the investors. The other important thing that has happened under the FPI regulations, and I believe that has become quite easier for the funds to be registered under this new regulation, is that now any fund can be registered as an FPI independently. It doesn't need its investment manager or an investment advisor to be also simultaneously regulated with SEBI. Unless, of course, there are certain situations where it needs the help of the investment manager, but otherwise the funds can be registered independently. All the earlier FIIs and sub-accounts have also been grandfathered under these new regulations, with the effect that now they are regarded as deemed FPIs, and they have continued to make investments in the same way as what they were doing earlier under the FII regulations. The other important relaxations, I would say, that SEBI has brought in is they have created a new category of FPIs, that is FPI category 3, whereunder they have allowed the non-institutional investors and even the individuals to be registered as FPIs and make investments into India. Under the earlier FII regulations, initially it's only the pooling vehicles that were allowed to be registered as broad-based sub-accounts. While, of course, as you may all know, SEBI had intermittently introduced foreign corporate and foreign individual sub-account categories, but for some reasons they haven't permitted any of these corporates or individuals to be registered. They also simultaneously came out with a different regime altogether, qualified foreign investors, QFI, under which the individuals were allowed to be registered as QFI, which of course now they have clubbed it under category 3 FPI regulations. So overall, the regime, of course, is shaping up well. But since it's only 10 months and there are still certain kind of unanswered questions, or there are certain issues which either the DDPs or the investors that are grappling. First, of course, is the appropriately regulated entity. Now, what had happened is, under the earlier FII regime, SEBI used to register entities as FIIs who were category 1 members of IOSCO. IOSCO, of course, is an organization of regulators. So whichever regulator is an IOSCO member, and any entity which is registered under such a regulator, SEBI used to grant FII registration. Under the FPI regulations, SEBI has put one condition that an appropriately regulated means regulated or supervised by securities regulator or banking regulator. To that extent, now they have restricted entities, those who are registered with securities and banking regulator. So to that extent, if any entity which is registered with CFTC may not be able to be registered as an FPI. Of course, we have had a dialogue on this issue with SEBI at that point of time, and SEBI said that they will look into this, and if there are any applicants which are registered with CFTC, they will try to register them with SEBI. But of course, they haven't yet come out with any clarification on that. The other, of course, problem that is being faced is the broad-based criteria. What had happened is, under the FII regulations, there were a lot of funds which were registered as sub-accounts, which had only 4 or 5 investors, because at that point of time, the broad-based criteria was that even though you have to have 20 investors, if there was any institutional investor, then you can have less than 20. Under the FPI regulations, as you may know, SEBI has tweaked that definition a bit, and have insisted that you have to have 20 investors, even if you have an institutional investor. So to that effect, a lot of fund entities which were earlier registered as sub-accounts and which have less than 20 investors, now will have to get sufficient number of investors that they fulfill this criteria when they convert themselves to FPI before their expiry of registration. The other, of course, aspect is the investment limit. As you all know, the investment limit under the FII regulations was up to 10% for any FII or a sub-account. Under the FPI regulations, SEBI has indicated that you can invest less than 10%, which effectively means up to 9.9% investment can happen. Of course, this is a minor thing, but the FII sub-accounts will have to keep it in mind that when they convert themselves to FPI, all the subsequent investments will have to be up to 9.9%. SEBI, of course, would allow the existing investments to continue with 10% till the time they divest on the floor of the stock exchange. One more issue that we have seen being faced by some of the investors is, of course, this investor group calculation. As you know, the 10% investment limit is given to each sub-account. But at the same time, SEBI has also prescribed that if there are any common investors into more than 2 FPI entities, then they would be regarded as investor group, and the investment limit for these FPIs would be clubbed together, so all of them would effectively get 10% investment limit and not an independent limit of 10%. It is interesting to note the way SEBI has been using the language for the purpose of this investor group into the regulations and some of the clarifications that they have provided. In the FPI regulations, in Regulation 23.3, SEBI says that investor group means same set of ultimate beneficial owners investing through multiple entities. So here you have used the terminology ultimate beneficial owner. in the DDP guidelines, which they have provided for the purpose of DDPs, they have indicated that entities having direct or indirect common shareholding, beneficial ownership, or beneficial interest of more than 50%, that will be constituted as the investor group. Here, of course, they have used the common shareholding or common beneficial ownership. In the FAQs, which they came out clarifying on this particular issue in question 58, they have indicated that this investor group is based on common ultimate beneficial ownership. Now here they are trying to say that so far as there is a common ownership and the ultimate beneficial owners, that should be regarded as the investor group. In situations where you have master feeder structures or where you have investors coming through different intermediary entities, at times we have seen some of the clients facing this issue as to at what level you would calculate this investor group, whether you should look at the percentage holding at the FPI level, or you have to go even beyond that. And even if you have to go beyond that, whether it is at the first level or second level, or even above that. Now, just to give you a simple example, let's say there is a fund A, which is registered with SEBI as FPI. Now, this fund A has 5 investors, 4 of which are holding 40%, and the 5th investor, which is, let's say, fund B, is holding 60%. Now, this fund B is also separately investing into offshore derivative instruments, ODIs. This fund B has then 2 investors, one of which is holding 60% into fund B. Now, pursuant to the recent circular, the clubbing now goes even to the ODI subscriptions also, which of course my colleague Richie will deal separately. But effectively, would this fund A and fund B be regarded as investor group, and hence their investment into, direct investment into the Indian shareholding by the FPI and indirect investments through the ODI which should be clubbed? Or if you look indirectly, actually the investor holding 60% into fund B, which in turn holds 60% into fund A, his investment into FPI is 60% of 60%, which is less than 50%, and hence it should not be clubbed. And that's where I think SEBI has to come out with some clarifications, but probably the stand that we are taking, that based on the language that SEBI has been using, and that SEBI says that you have to look at directly and indirectly the investment of the ultimate beneficial owner into the FPI entity, you have to calculate as to how much percentage he is holding in the FPI entity and accordingly decide whether it would be an investor group or not. The other point we also see some issues being raised are the opaque structures. Of course, as you all know, SEBI has always been having some issues with the PCCs, that is protected cell companies. And initially they used to reject all the applications from the protected cell companies. Over a period of time, of course, there was a declaration come undertaking they have taken from all the FIIs and sub-accounts that you are not a PCC. Subsequently, after about 2-3 years back or so, they about a year back, they came with a relaxation that subject to certain conditions, they would allow the protected cell companies to invest into India so far as they are required by the regulator or by the government to ring fence their assets and liabilities. And subject to certain conditions, SEBI said they will allow such kind of opaque structure. But then the issue comes up is there are certain entities which are not per se registered as a PCC or as an SPC. For example, we have in Luxembourg or in Ireland entities like SICAVs, which are umbrella funds and have different kind of funds or different cells through which the investments happen. Whether they would be regarded as an opaque structure or they would not be regarded, that is what I think SEBI has to clarify, because there are still certain questions in the minds of a lot of investors. And of course, some issue we generally hear from some of the investors is on the KYC norms. especially for category 3 FPI registered entities, that the KYC requirement asked by some of the DDPs is very onerous, and at times the individuals or ultimate individuals are hesitant to give details, personal details like passport copies, or even if they want to give these passport copies of any other documents, they are not sure whether they would be kept confidential or would that be shown to anyone or so. So to that extent, maybe SEBI has to see if some relaxations can be done into that, or at least they have to come out with some set of forms and give some kind of a comfort to the investors. So to that extent, even if FPI regulations now are set and the DDPs already are considering it, I believe there are these few issues which SEBI has to deal with.
Thank you, Kishore.
Just, I'll quickly add. I think the important thing is, once the regime moved from SEBI regulating and registering the FIs at that time and FPIs now directly, versus getting the private players in the market, termed as DDPs, as doing the registration on behalf of SEBI. There's a lot of, we anticipated that the DDPs some of the DDPs will might take a very technical view of the regs. And anything where there is requirement of interpretation will be taken very conservatively. I think the pushback there that the industry as a whole, and especially the law firms, will have to take initiative is convincing the DDPs to go back to the intent that SEBI had behind these regulations, and have a more intent-based onboarding process. Otherwise, it will become very painful for the market. So, for example, one of the main reasons that we all forget why all these technical requirements of opaque structures, SPCs, MCVs were put in place was SEBI's concern again on round-tripping of money from India through Mauritius, Singapore, wherever these various structures are based, and having certain structures where you couldn't see where the money is flowing from, and Indian residents investing in their own country through the ODI route or through the FPI route, and hence, circumventing Indian regulations. So once you overcome the spirit of the once you understand the spirit of the regulations, if the DDP and the broker themselves and the ODI counterparty is sure that there is no such violation happening, it's easier to push the DDP to get you onboarded on that basis. That is a key element, I think, all of us miss when we look at these onboarding processes.
Yeah. So I think this is the whole new regime that has really now been kicked off, and is working all right. I think at the moment looks like very well. And the next thing is, Richie, I may ask you, what are your thoughts on synthetic participation through derivatives? Are there any issues in who are eligible to subscribe ODIs? That would be helpful.
Sure. Thanks, Nishit. I think just to give you a little background of what we are talking about when we talk about synthetic participation, as well as what my colleague Kishore also touched some time back. So pretty much as opposed to direct participation in Indian public equities, there is also a separate route which allows foreign participants to come in through ODIs or derivative instruments, more in the nature of, let's say, a total return swap, TRS, where one party is entitled to cash flows from another party, and this cash flow is derived from the underlying asset class. Put into the Indian context, this would mean if an eligible foreign portfolio investor, FPI, were to issue a derivative instrument to another entity which is eligible to subscribe it, the underlying cash flows which the issuer FPI would be passing on to the subscriber of the derivative instrument would be based on underlying assets which would be either A, listed securities in India, or those which are capable of being listed. So here, some of the underlying assets you could be looking at perhaps more traditionally could be, shares and securities which are listed on the stock exchange. It could be listed non-convertible debentures if you're doing a structured sort of a deal. It could also be units of a mutual fund. Mutual fund, just to put it in context, would be something equivalent to, let's say, units of a UCIT or a 1940 Act company in US. Something similar we have in India, like a mutual fund. Even those units are eligible for underlying asset class, on top of which you can write a derivative instrument. These typically are subscribed by investors who do not want to take the shareholder level risk, or who for certain reasons would not want an Indian asset class, either perhaps it's rupee denominated or otherwise, sitting on their balance sheets. So it is one way of taking an economic exposure without directly holding the underlying assets. Now, some of the issues which got thrown up when the regime makeover was happening, under the old FI regulations, an ODI subscriber, a derivative subscriber, could have been even a broad-based fund which was not regulated, as long as the manager is appropriately regulated. But under the new regime, what has happened, and this is where the whole discussion gets quite technical, is under the new regime, the regulations required that an ODI subscriber has to be regulated by an appropriate securities market regulator. So the stress are on the two words: A, it has to be regulated, and B, it has to be regulated by an appropriate regulator. Now, the definition of who's an appropriate regulator was missing under the new law, which is where the securities regulator in India, SEBI, came out with a clarification saying that for being regulated by an appropriate regulator, you refer to another section in the regime, which unfortunately not only said who the appropriate regulator was, a securities market regulator or a banking regulator, but it also explained that, okay, what is being appropriately regulated means, which is that if you're regulated in the same capacity in which you're investing in India. My apologies for using the word regulated so many times in one sentence, but unfortunately, it just can't be avoided in this discussion. So the confusion arose that, okay, is an eligibility requirement to subscribe or hold a derivative in India, would it mean that we need to be regulated, or would it mean we need to be appropriately regulated? The difference between the two is quite out there, because SEBI has in another clarification come out that they don't consider an investment holding company in Mauritius as being appropriately regulated, even though the fact is that they are regulated in some form or shape by the financial securities regulator in Mauritius, FSC. So would such an entity be eligible to subscribe to ODIs? Answer, it's slightly, there is some confusion out there, which, we can obviously help navigate in certain case-to-case basis. So this was one issue which I think the derivative subscribers are, facing in India. The second one was, more to do with who is eligible to subscribe to ODIs. So like my colleague Kishore indicated a while back, that an ODI subscriber has to be a non-opaque structure. Now, opaque was defined to mean either you have a protected cell company or a segregated cell company or anything which is equivalent to that, or you have a structure which allows you to ring fence the liabilities between two different portfolios of the same entity, or ring fence the enforcement against the investors. Or you have a structure which avoids disclosure of who the beneficial owners are. Now, clearly, given the maturity of most of the leading financial jurisdictions, a disclosure of who your ultimate beneficial owners is not that much of a challenge, because pretty much all mature jurisdictions now have this much of expectations built in, especially thanks to the base erosion profit shifting BEPS report, which OECD is working on. So I think the biggest concern was that, okay, if we have a multi-class structure or a multi-cell structure, would we be considered as opaque or not? Now, there are views out there, but based on applicable law, a view can be taken that perhaps a multi-class structure, where you are only trying to achieve a contractual ring fencing, or the ring fencing is only in the constitutive documents of the entity, as opposed to, let's say, a protected cell regime or a segregated cell regime, like in Cayman Islands or in Mauritius, where the law by itself introduces the ring fencing on the structure. So accordingly, these are the issues that we are gradually seeing more and more, both the issuers as well as the subscribers facing, where they see some amount of struggle, where are they eligible anymore or not. Clearly, if you were a subscriber to ODIs under the old regime, there is a grandfathering provision. So this issue is just academic for the previous subscriber to ODIs. But any entity which has been recently set up or been set up in 2014-15 regime, clearly there is some amount of challenge which is still out there.
So what about NRIs? Kishore, you want to say something? Can they participate? And what's happening to them, because that's a very large class of people around the world.
Sure.
And if you can say a few words.
Yes, sure. Actually, NRI is such a category that in India it's loved by everyone, especially nowadays by the new government, because they want more and more monies, except of course by SEBI. Somehow they hate this NRI category for coming through the FPI regime. The NRI, of course, has been a restricted category because the restrictions was there in the FI regulations, as also it is there in the FPI regulations, that an NRI cannot be registered as an FPI. Of course, to that extent, SEBI also has clarified that if there is a fund and if there are NRI investors which are coming through this fund, then it should be okay because it's a pooling vehicle. And in a pooling vehicle, of course, NRI generally don't have any management or any control. They are just one of the many investors who can, who are investing, and that fund is managed by an independent investment manager. So to that extent, SEBI, of course, has, it seems, no problem fund being registered as a FPI, even though it is held 100% by the NRIs. But of course, they have an issue if there is an NRI which is setting up a company, and that company or a corporate is being registered as an FPI, because they have given a clarification into FAQs that in such a situation, such a corporate will not be allowed to be registered as an FPI. And I believe to that extent, some of the local participants had met with SEBI, and SEBI has clarified that, of course, now this category 2 and category 3, so whether this entity can be registered as category 3 and whether it can have NRIs into it or not. I believe SEBI has clarified that so far as NRI are investing less than 49% into that entity, they have no issues in registering that entity as an FPI. Frankly speaking, we really don't see what logic SEBI is trying to put, because you can have a situation whereby NRI is putting money into one corporate entity to the extent of, let's say, 30 or 40%, registering that as FPI category 3, and again investing through some different corporates being registered as FPIs. So to that extent, he will try to invest through more than one entities, but keeping the NRI participations to less than 49%. This, of course, as you all know, the restriction comes because of the fact that NRI were always given a separate route, that is NRI portfolio investment scheme route, under which the NRIs are allowed to invest up to 5% or to make portfolio investment up to 5%. To that extent, we feel that NRIs are put to a certain disadvantageous position vis-a-vis any foreign investor or foreign individual, because today you may have a situation where you have foreign individual setting up a corporate and registering that as category 3 FPI and investing into India up to 10%, as against which an NRI cannot incorporate a corporate or a company and register that just because he is an NRI. So maybe one option is that SEBI really will have to have a serious look at it, whether they really want to continue with that separate NRI portfolio investment scheme, and instead of that, just allow all the NRIs to come through FPI, where they can either individually or through their own corporate to start investing up to 10% instead of the 5% limit.
Thank you. But what about tax? I think, Rajesh, ultimately, tax cuts into your pocket, right?
No,
So,
ultimately, if you're talking about India, you need to talk about tax.
Okay.
I think the big issue really that's come about in this particular budget is really the imposition of minimum alternate tax as far as foreign portfolio investors are concerned. And the interesting part is that genesis is really a clarification issued by the government saying that from 1st of April 2015, we don't want to impose what you call as minimum alternate tax on foreign portfolio investors. The whole concept of minimum alternate tax essentially is that if you as a corporate, if the tax that you're paying to the government is less than 18.5% of your book profits, in that case, you have this levy of minimum alternate tax saying that you effectively then have to pay 18.5% at least as minimum taxes to the government. The understanding that was always there was that this minimum alternate tax ought only to apply to Indian residents or probably to foreign companies having a permanent establishment or a permanent presence in India. Because the way the regulations were framed was that that if the tax that you're paying is less than 18.5% of your book profits computed under the Indian accounting standards and under the Indian Companies Act, in those situations you have to pay the minimum alternate tax. However, what had happened was that a couple of years back, there was one ruling that came out from the Authority for Advanced Ruling, which is more akin to a private letter ruling, which effectively said that even if you're a foreign portfolio or a foreign investor, you can still be subject to the provisions of minimum alternate tax. At the same time, there were a lot of other positive rulings which said that no, the concept of minimum alternate tax does not really apply to a foreign company not having a presence in India. I think because of the conflicting judgments, a lot of people had actually approached the finance ministry saying that please clarify this particular issue. And the finance ministry very happily obliged them and said that, well, from 1st of April 2015, there is not going to be a levy of any minimum alternate tax as far as these FPIs are concerned. The problem that was there was that it effectively opened a Pandora's box for all of the previous years. Because the tax authority said, well, this is a clarification that's come in from 1st of April. So as of from 1st of April, yes, we are not going to levy any minimum alternate tax. But for all of the past periods, we are going to reopen your assessments. And wherever assessments have not been completed, issue notices to levy minimum alternate tax on pretty much all foreign portfolio investors for past periods. I think this has become a pretty much a huge issue because I think the quantum that people are talking about runs into around $10 billion of taxes for past years. I think there are around 100 odd notices that have been issued to various foreign portfolio investors on this particular issue. The way we have always looked at it is twofold. First, that as far as a foreign portfolio investor is concerned, most of them are coming through either Singapore or Mauritius. And you have a treaty provision which specifically covers the treatment as far as capital gains are concerned, to say that India does not have the right to tax, but it's actually Mauritius or Singapore. And the treaty effectively provides for a complete allocation of taxing rights as between the two countries. So imposition of a minimum alternate tax over and above what is provided for under the treaty is not something that is permitted under international law. The second approach is also to say that, well, your provisions relating to minimum alternate tax impose a tax on people who are maintaining their accounts or books as per the Indian Companies Act. As a foreign company, if I don't have a presence in India, I don't maintain my books as per the Indian Companies Act, and therefore to that extent there should not be a tax consequence on a foreign investor who doesn't have any presence in India. And thirdly, also from even looking at it from a constitutional law perspective, this is effectively a situation where you're treating unequals equally, where you effectively have somebody who doesn't have any presence in India and you're trying to tax him on the same footing as a domestic resident, which again has constitutional law implications. But having said that, today the fact of the matter is that this issue is out there in the open. The finance ministry has pretty much indicated that they are not going to interfere because the matter is currently before the Supreme Court. This is in the case of Castleton, where the advanced ruling had given a negative ruling. And the matter has gone up to Supreme Court, and what pretty much the finance ministry has indicated is let the Supreme Court decide on the matter for past periods. What we have given you is effectively a clarification for future periods, but as far as the past is concerned, that's not something that we want to look into, because we promise that we will not undertake any retrospective legislation, so that goes for good and for bad. So that's the stance which is currently there. So I think that's really the big issue which is facing foreign portfolio investors. And again, there are challenges on what would happen if this particular tax is actually imposed, especially on a lot of players who have issued ODIs in the past. How do you sort of recover it from the ODI holders? So all of those issues are currently out there. The good bit is that at least on a going forward basis, you know exactly where you stand from a legal perspective. But yeah, the past is always presents a cloudy picture in India.
Yeah. In a moment, I would like to come back to you on anti-avoidance measures that are, India is seeking to implement. But before we go into that, can you, Richie, tell us what implications arise out of this 10% cap rule, that clubs both direct and indirect participation and derivative exposure. So overall, what is the implication of all this?
Right. No, so I think just to quickly summarize the 10% rule to begin with. So basically, the Indian securities regulator, and for good measure, believes that the condition of Indian public equities market is slightly fragile. So to reduce the volatility linked to any investment or divestment decisions by any single investor, foreign investor to be specific, they limit the amount of participation that a foreign investor can have on Indian public equities to 10%. So the reason is that, okay, no one investor by virtue of their own individual decision should increase that much volatility that it entirely destroys the particular script on the volatility side. So that was one restriction. And again, just to put the context, they also look at it only from a volatility perspective. So if you look at the cap of 10% on any foreign portfolio investor, it is only with respect to the investment limit. It does not take the color of securities laws. So if, let's say, a derivative investor, this is what the circular in effect does. It says that any derivative investor, an investor holding ODIs, etc., and also having direct participation through portfolio investment route, together cannot use the two different regimes to take a stake beyond 10%. Now, this is, like I indicated, only from an investment limit perspective and not from securities laws. Like, so from a takeover code perspective or insider trading laws, you still do not look at the two regimes in a combined basis. This is different from other geographies, let's say, where in US, to give you an example, in 2011, there was a ruling in the case of CSX versus Children's Fund, where the fund had direct investments, but also had ability to instruct the issuer on the ISDA contract note side on how to vote on the underlying securities that it was holding through the derivative position. So that was a classic case where even though your direct participation was below a certain threshold, you on the other hand had the ability to instruct the issuer on the ISDA side on how the underlying assets should be voted on. So clearly you had demonstrated the virtues of ownership, both on economics being passed on to you as well as the voting rights, to actually make a case that even though what are synthetic participation is actually a case of direct ownership. So unlike those, the securities laws have still not been sort of brought on board, and the clubbing of investments on 10% is only from a limit perspective. The other issue which is now coming up as far as clubbing is concerned is that the issuers have now been expected to put in place mechanisms by which they can monitor whether the ODIs that they've issued are held by investors or by subscribers who are keeping their investments below the 10% limit. Now, like I said, ODI is more in the shape of the ISDA contract notes. So you have the contract and you have an India side letter. The issuer in its side letter would always seek a representation from a subscriber that you undertake that you will not use the ODI contract position to breach the 10% limit. So this is perhaps the mechanism that they have put in place for the time being. But the issue arises from a subscriber's perspective, that if I'm holding ODI positions, and if, let's say, I also have an allocation to any other discretionary third-party fund which has India allocations, and let's say perhaps if I'm tripping on the 10% rule based on my holdings onto the fund, how do I as a subscriber monitor my positions? Solutions are out there. There are some crude solutions which are being worked upon. There are some mechanisms actually being placed by more institutional of LPs. But the issue still remains to be resolved, and hopefully perhaps SEBI, who is cognizant of this issue, may come back with some clarification as to what are the actual practical mechanisms that investors and subscribers can rely on to actually demonstrate that they are on the good side of the 10% clubbing limits.
Thank you. As I told you earlier, Rajesh, what are the anti-avoidance measures that India is seeking to implement, and what implications, if any, are there for portfolio investors?
Sure. Just to take a step back, because usually in most countries you don't have a problem when you have a foreign portfolio investor who's investing in the country. Most countries don't really tax those gains on the basis of source rules, but rather based on the residency-related requirements. India is one of the countries which effectively says that, well, even if it's a foreign portfolio investor investing into India, we do have the right to tax, subject obviously to the treaty benefits that are there. Now, there are two different issues which effectively arise. One is the fact that today as a FII, again, in most jurisdictions, this would have been a business income that they'd have gotten, so there would not have been any tax consequence, even if they're trading on the Indian exchange. But under Indian laws, you effectively treat this as capital gains. There is a deeming fiction that's out there effectively treating all of this income as capital gains. So you go back to the same issue as to the general anti-abuse rules, saying that if I'm coming in through a Mauritius FII or a Singapore FII, how will the general anti-avoidance rules play along? The good bit, obviously, is the fact that today it is postponed to 1st of April 2017. So that at least gives at least you have sort of put in the ball further away to ensure that at least for the immediate future, as far as any of the entities that are being set up, there's not going to be a real issue. Though what we have seen in the past is that a lot of the FII entities or FPI entities are actually sort of relooking at their structures to see whether, well, should they actually come in through Mauritius, or should they shift their platform probably to a Singapore-based platform. So that is one issue that is out there. The second issue that is also there is really in respect of the derivative contracts, where in most cases where FPIs are issuing derivative contracts in respect of the underlying stock, the question that's always there is that, well, if the general anti-abuse rules comes into play, how will this impact these kind of contracts? In fact, a couple of years back, there was also a huge debate as to whether the indirect transfer tax provisions would also apply to the derivative contracts. But I think now you're restricted more along the lines of the general anti-abuse rules. But as I said, at this point in time, because your general anti-abuse rules are being pushed out 2 years down the line, we have to see how it actually evolves to see whether specific carve-outs are going to be provided or safe harbors provided in respect of some of these derivative contracts and into some of the investments which are made by FPI entities. So that's probably a conversation that's going to happen over the next year or so when the Finance Ministry releases a new set of revised general anti-abuse rules. But at least at this point in time, what you really have is a deferral, and that's what I think, at least from an immediate perspective, most people wanted, because otherwise they were coming into place from 1st of April 2015.
Thank you so much. Are there any comments anyone would like to make, or questions at this point in time? Yeah, please introduce yourself and ask a question or a comment.
Yeah, no, thanks a lot. I'm Amit from Newquest Capital Partner. In this budget, government also announced merging FDI and FII limits. Has there been any clarity on that part? And what does that mean for private equity investors?
So what the clarification which the government was, or the finance minister was really making, was in terms of the caps that were there. Because in a lot of sectors, you actually have a separate cap as far as FDI is concerned and a separate cap as far as FPI is concerned. What the finance minister essentially said was that, listen, I don't see a need for having segregated caps within or sub-caps, really, as between FDI and FPI investment, and that's what I'm going to really club together. I think you probably have to wait for the consolidated policy and the changes to come in, which is where all of this will probably take effect.
I'll just like to add one more point. So the point continues to remain that as an individual portfolio investor, I still cannot take exposures in any equity beyond the 10% limit as an individual investor. But as far as the sectoral allocation is concerned, if as an FPI I'm also doing FDI investments, then the different the bucket into it in which I fall, or the sectoral itself has its own limits, like a 26% or a 49% rule. There were different compositions, like part FPI, part FDI, etc. Some had buckets for NRI investors' investments also. So that is where the regime is going to sort of have a shake-up. and you'll have a sector being identified with one sectoral limit. The other point is, like, very recently we have been seeing increasing trend where a lot of FPI clients also having a side pocket to do illiquid strategies. Overall also globally it's been observed that a lot of value being created in the private equity side as opposed to public equity. Companies are tending to stay, private much longer than they were traditionally. You have examples of Flipkart, Facebook remained public, private till it reached 100 billion plus. You have Uber, etc. So we see a lot of hedge fund clients who also want to do illiquid strategy alongside their very liquid, with redemptions on the public equity. So you see a lot of those combination structures now.
Sorry, just to add one more point is, I think FPI investors should be careful because, it's not just the FPI regulations or the SEBI's regulations. There are other regulations also that we should be mindful of. For example, the FDI regulations, whereunder it has been clarified that if there is an FPI investor who has this limit of 10% and making investments under the FPI regime, if the same entity makes investments under the FDI regime separately, he will still be making investments within that 10% limit, and he cannot go beyond 10%, even if it is an FDI investment. And if any other FDI investor may be allowed to invest more than 10%, but not an FPI investor.
Yep.
Hello. Hi.
Go ahead. Who's that?
Yeah, that's me.
Oh, okay. Your name and...
I'm Nikhil Iyer from Kotak Mahindra, Singapore. I have a question for Richie. An ODI, if I want to buy an ODI, and am I eligible to buy it if I am not broad-based?
Correct. So broad-based was not a requirement. What is required is you should be regulated by an appropriate regulator. B, because of the circular which came out, you also should not be in opaque structure. So opaque would be like, let's say if you're a protected cell or a segregated cell company or a multi-class structure, and there's some debate around the class structure at least. As long as you are fulfilling those requirements where you will be coming up with your beneficial ownership, etc., then of course the rules around the NRI participation also, like how much NRI participation can you take, because a direct issuance of ODI to an NRI is not possible. So keeping these parameters in mind, even if you are not broad-based, you should still be eligible otherwise.
Okay, I have another question. There are certain jurisdictions like Australia where the funds are not regulated, but the investment manager is. So in such a case, how do they purchase ODI?
Unfortunately,
is there a solution?
As far as them directly subscribing is concerned, that is an issue, because clearly now the regime has shifted. You can no longer rely on your manager, the subscriber itself, and this is more a question of form over substance, frankly. The entity which is subscribing to ODI has to be regulated itself. So if you're dealing with an unregulated, the only alternative I could perhaps foresee is, let's say, if it were to become a shareholder to another entity, which in turn is regulated by the appropriate regulator, perhaps you could explore those sort of structures. But direct subscription by an unregulated looks difficult.
Unless, of course, Nikhil, if that entity was already subscribing to ODIs prior to the introduction of FPI regulations, SEBI has grandfathered such entities and have allowed them to continue to make investments into ODIs. But if it is a new entity which wants to now subscribe to ODIs, that will not be possible.
Yeah, we have a question there.
Hi, I'm Yagesh Pandey from Citibank. My question is, you were discussing when the FPI regulations were about to come out, right? There was a roadmap saying the FPI, FDI, and FPCI regulations will be all merged into one. So is there a roadmap for that still in place? And you said that the limits between FPI and FDI, Kishore, there is some restriction in FEMA or the RBI rules, right? Saying that once you have 10%, you can't cross. But how does the interswitch really happen? It's not very transparent because FDI is typically private investment and FPI traditionally is listed investment. So let's say if I want to really increase my shareholding in a listed company beyond 10%, right? And that sector is eligible for 26% or 49%. Can I make that transition? How does that really work in practice?
Well, for the same entity to make investment into this Indian company, it would definitely be difficult because that restriction is on that particular entity. So what has happened is SEBI, of course, may have come across situations where there has been an FDI investments made by an entity into an unlisted company, and with that unlisted Indian company has gone for listing and has become listed. So if the foreign entity which has made an FDI investments already now wants to make FPI investments, it would not take a separate 10% investment limit, and that would be clubbed. That is what actually SEBI meant. But of course, we have had situations whereby for some of our clients, we have segregated this FPI and FDI investments to come through different entities within the same group. And that is what should be possible because the restriction is only on that one entity which is registered as an FPI.
And it actually goes back to the intent that you were talking about, the roadmap. You know, when it came out, we actually very strongly with IVCA pushed back on it because you can't club FVCI with an FPI regime. FVCI investment, structure was put in place really for the private equity guys to come through that route. In fact, we've been pushing for the opposite, which is liberalize the FVCI regime, because you have three buckets. You have the short-term investors, which is your FPI investors, and their limit is 10%. And then you have the midterm investors, which is your FVCIs or your private equity guys who need an exit after 5 to 7 years to come back with more capital. And then you have the long-term investors who are looking at, setting up in India their long-term franchise business, etc. Right? So those three buckets have to remain separate. The FI or FPI and FDI regime being, or the limits being merged made sense simply because, if it's a listed entity with that individual limit being put at 10%, that's taken care of. So you really don't need that 2449, etc.
Yeah. Yeah.
This is Jimmy Hai at JP Morgan. I just want to clarify the earlier comment regarding broad-based requirements. For MCV structure where you have multiple share class, considering the 2010 SEBI circular, will it supposed to mean that the broad-based is a requirement for MCV structures having various share classes? And what happened to all those share classes that may not invest in India?
About investments, direct investments as an FPI or under the ODIs?
Under ODIs.
Well, under the ODIs, of course, this broad-based criteria ideally is for the opaque structures, if you are referring to that 2010 circular. As I said, because what the relaxation at that point of time came, especially for the opaque structure, is that you can make investments provided the entity as a whole is a regulated entity and that each sub-fund is broad-based. And of course, the third condition was there. So to that extent, we believe that this particular condition of broad-based is applicable to the opaque structures as such, which is generally the PCCs. Because if you look back to the declaration cum undertaking, which SEBI has been taking from all the FIIs and the sub-accounts, they have differentiated between the PCC and SPC entities and the multi-class entities. So while as per the declarations, the PCCs and SPCs cannot make investments, they still have allowed the multi-class vehicles, MCVs, to invest depending on whether it is a common portfolio or segregated portfolio.
Yeah. Any more question? Yeah. We are slightly running short of time, but we'll...
Yep. A very quick
always,
question. This is Kelvin from Deutsche Bank. We mentioned about the fund which is regulated by Mauritius FSC, they're no longer considered as regulated and not eligible to trade ODIs. Will the grandfathering exemption apply to those?
So I think just to immediately answer, then yes, if an entity was an eligible subscriber to an ODI, the grandfathering should work. The grandfathering requirements also say that if there's any change on the basis on which you claim your grandfathering, so how your shareholding pattern was structured, etc. If there's any change or if there's a change of manager, you will have to inform SEBI about it. So because the relaxation on grandfathering was on a basic fact pattern, and that fact pattern would have had changed. So that's an immediate answer. But just to take a step back, the point is that the requirements only is that you have to be regulated by an appropriate regulator. If you are a fund, then you are a collective investment vehicle in Mauritius, which is a different regime from an investment holding company, which is appropriately regulated by FSC. Then there is no doubt about it. So even if it was not grandfathered, a fund should be eligible.